And welcome to Law Call on WLOX and WDAM. I'm Ken Flanagan. So happy to have you along on this spring break-ish leading into Easter Saturday night. We have a great show, Fighting the Insurance Company. Are you dealing with medical bills? Are you dealing with the paperwork of an insurance company, either your insurance company or their insurance company? We have got the show for you tonight. The phone lines are now open, 896-0713 or 1-800-349-0713. That phone number is good from Lucedale to Long Beach to Laurel, Mississippi, and all points in between. Please give it a shot tonight. We'd love to hear from you, plus our email questions of the week. Now joining me, as he does every Saturday night, in one shape, form, or another, our friend and yours, the Bulldog. Here it is, Jim Reeves from the law firm of Reeves and Medier. Jim, safe to say you have fought insurance companies your whole career?
Absolutely, my whole career. Early in my career, I defended insurance companies for the first 4 or 5 years.
Oh, wow.
Then I switched to
I don't think I knew that, Jimmy.
to the good side, yeah.
I didn't realize that you were on the dark side of the force.
Cut my teeth on the dark side.
And then switched over.
That's right. And so, when we say fighting insurance companies, you're covering a lot of ground because everything in this day and age, you're typically dealing with insurance. If it's a legal process and a loss, be it a property loss in a hurricane, a slip and fall somewhere on someone's premises, an auto wreck, a commercial 18-wheeler wreck, you're dealing with insurance, even in COVID losses.
Sure.
Insurance. So you're dealing and fighting with insurance companies regardless of what kind of claim you may have, almost always. And there's some general rules that apply when you're handling an insurance claim that you need to be aware of, tricks that the insurance companies use, things that you can do to combat it, and when you need to use an attorney.
And Jim has come fully prepared for tonight's show. He has done all of his spring break homework, and he has prepared 3 items for you to kind of go over if you think you can't afford an attorney. Jim, are you ready for them?
I'm ready.
Your 3 big tips.
I'm ready. I know
your
these
spring
well.
break tips are right here if you can't afford an attorney. I guess the first one, Jim, is people sometimes get worried that they just can't talk to you.
Well, big concern. A lot of people say, I don't have the money for an attorney. What do I do? Attorneys that handle most types of claims, that bring claims for individuals or families like we do, will talk to you about your claim for free. Either over the phone, come into the office, we sit down and talk to you about the claim, what we think about it, what we need to do to investigate the claim further to see if we can proceed, or quite frankly may tell you, you don't have a claim. But those conversations typically cost nothing other than a little bit of time on the telephone or an in-person visit.
Jim, talk about the percentage. You hear a lot about the percentage and stuff like that. The fact is, it's just part of it, but that's really what allows a client to come to you and not to have any money out of pocket.
When I say we talk for free, that does not mean we're communists, okay? We want to be paid.
See that coming.
We want to be paid for our services too. And so, but the beauty of our system is that it's contingency. Meaning you can have the best lawyer, or a lawyer every bit as good or better in some circumstances. I can think I'm better. Than the insurance company's attorney, and you're able to do that. You could never do that if you had to pay $600-800 an hour, which is what they pay quite often their attorneys in serious cases. But you can hire an attorney like our firm on a contingency basis, and we go toe to toe with the largest companies in the world routinely, and come out on top, more than our fair share. And we're able to do that because of this contingency-based system. The average person could never afford to go into court and take on a massive insurance company, a General Motors, an offshore company, a commercial trucking company.
Get the investigators and research.
You could never do it if you had to pay hourly like the companies do.
Right, and so then you base your percentage off of the potential. And then, Jim, I hate to say it this way, but it's true. If you don't win, then your client,
That's absolutely, and that's the other beauty of it. So if you go to court on a contingency fee basis, we take a percentage if it's a recovery.
Right.
If we don't win, we hope we make it up in the next case, and you owe us nothing, not expenses. And a lot of times, people don't understand this. There's a fee for the services for attorneys take for trying your case, preparing your case, appealing your case. But there are also a lot of expenses in modern litigation. If you're taking on, for instance, a commercial trucking case, we have accident reconstructionists that have to put together the accident. A lot of times a regulations expert, an economist, other experts who are required to be paid up front. They don't work on a contingency. And our firm then has to front that money and hope that in the end, if we've got a meritorious case and we bring it and present it properly, we're able to make a recovery for the client and recover those expenses. But if we don't recover for the client,
right,
nobody owes anybody anything.
There you go. Like you say, Jim, we had a great email question come in this week. It came in actually last week, but we're like, no, this is a perfect Jim question for the show. It came in from David. David says, my brother was seriously hurt when a tractor trailer had a blowout. The truck swerved into his lane and crushed his car. I'm sure the driver didn't expect this, but is he still at fault somehow? Great question. A blowout that just happened, of course. I'm sure the driver wasn't the trailer truck driver, but there's still liability there, isn't there?
Absolutely. So let's unpack this a little bit. So commercial trucking company has a duty over and above an average driver, an average, me or you on the road, Kenny.
Okay.
They're trained, and the carrier is more important than whether the driver's responsible, it's whether the company's responsible. So let's look at some potential here. Obviously, you wouldn't think a driver would want to have a blowout, right? He's not intentionally doing that. But did he check the tire pressure before the trip?
Right.
In most of these cases, companies have a pre-trip checklist that a driver's supposed to go through, checking the tires to make sure they're properly inflated, make sure there's not some anomaly or something in the tire. Among them, a lot of other things they're supposed to check before each and every trip. Was that done? Was that documented? Another aspect of this might be a potential products liability claim. Maybe the trucking company did everything right. There could be a defective tire. I was involved in litigation with Ford Firestone 20 years ago. I
remember you talking about that.
There were hundreds of cases all over the year, the country, actually all over the world. We had a ton of cases in South America too, involving defective Firestone tires. So yes, is somebody responsible? Probably, not definitively. Sometimes everybody does everything right and a tire still blows out. Maybe somebody accidentally ran over something just a couple of miles before the blowout.
Right.
You don't know, but you don't know unless you hire an attorney and investigate it.
Sure.
I promise you, in these kind of cases, the trucking company has investigated it thoroughly, has documented the evidence in a light most favorable to them. And so the lesson, especially involving a commercial trucking accident, is get an attorney and get one early because they need to be doing work on your behalf, just like the trucking company's lawyers are doing work on their behalf.
Absolutely. All right, I knew you were going to like that email question. I knew it as soon as I saw it come through the email box.
It was a good question.
It was a good question. I really do appreciate all of our email questions that come in. All right, let's get to our final email question of the week. This one came in very timely as well on that one. Jim, it says, is there a time limit for when a person can sue another property owner for an injury that occurred while working on that person's property?
Yep.
I love this question because, I mean, we've all probably been there in some way, shape, or form. Certainly a family member or friend.
Yeah. So same in Mississippi. I assume this is Mississippi. Mississippi, the general rule is there's a 3-year statute of limitations from the time an event occurred, okay? And that's the fallback statute. That most things fall within that 3-year statute. It could be, depending on who the property owner is, whether it's a government entity, an agency, et cetera, it could be as short as 1 year. It would, in most cases, almost never be more than 3.
Right.
The lesson in that is don't wait. If you have a serious injury, pursue it quickly. Because look, the other thing is, I tell people, not only is the statute running, but you don't want this hanging over your head for years.
Absolutely.
Go ahead, pursue it. Figure out if you have a claim. Figure out if you can get it resolved so you can get on with your life. But, you need to act quickly. It could be as short as 1 year, most likely 3 years.
Gotcha. And it is important. Jim is right. We do broadcast into Mobile County and over to some of the parishes in Louisiana, and the rules do change over there, don't they, Jim?
Right. Generally a year in Louisiana, generally 2 years in Alabama, as a general rule.
So be aware that the clock is ticking on that. Jim, I don't know where the time goes. Boom. We really appreciate everybody staying up late with us after the basketball game. We'll be back next Saturday night, late after the basketball game as well, with Matthew Medier, and we'll be taking more of your legal calls and questions on the air. But until then, good night.